Okay. Well, welcome back, folks, to another episode of American Genesis, where we're talking about the creation of America's founding documents. And this is, I think, going to be the final episode before we proceed into a new set of presentations starting next week on the Civil War and Reconstruction. So let's get started. We've been talking about the 14th Amendment for the last couple of weeks, and we're going to finish real fast. We're going to run through these pretty rapidly today. Um, the last part of the 14th Amendment, there was two clauses that we haven't talked about. One of them basically had to do with the representation, the apportionment of representatives in the House of Representatives. Remember, the original Constitution provided for what they call the three-fifths compromise, where each state's slave population was apportioned at three-fifths. So, since they abolished slavery, the former slaves would now be given full weight for purposes of apportionment. Well, the Republican leadership wasn't for sure they wanted to do that. Even though they wanted to free the slaves, now they were faced with a dilemma. If they freed the slaves were now free by the 13th Amendment. Now they were faced with the dilemma that the slaves would be counted for representation, which would give the South more voting members in the House of Representatives than they already had, which they already had a majority before the Civil War. So the two solutions were pretty obvious to them. Either they had to reduce the congressional representation of the former slave states by making representation dependent on the number of legal voters, or they had to guarantee free slaves the right to vote. Well, they didn't want to do that originally. So number two, so they basically chose to apportion representatives. But that didn't work because as soon as they did that, the slave states figured out that they could, change the whole situation again by instituting all these what we call Jim Crow laws. So eventually, they end up passing the 15th Amendment, which gave the slaves the right to vote and doing away with the three-fifths clause totally. And I know it's kind of complex, but that's basically what it did, that section of the 14th Amendment. Finally, the last part of the 14th Amendment had to do with a clause that disqualified Civil War Confederate state leadership, unrepentant former Confederates. Now, what was happening was that some of these unrepentant Confederate leaders were being reelected now, since as the states were reconstructed and were sending representatives back to the House and the Senate. They were unrepentant Confederates, like Alexander Stephens, the vice president. And he was absolutely not repentant for what he had done in the Civil War. So the Senate disqualified him. They said, we're not going to allow you to be in the Senate. And so they decided they needed to pass. And, part of the 14th Amendment had to do with disqualification of any official who, in violation of his office, was engaged in insurrection or rebellion. That was kind of rendered moot later on because 1872, Congress passed what was called the Amnesty Act. And it was a gesture of unity which removed the disqualification for all but the senior Confederate leaders like Robert E. Lee and Jefferson Davis. They were eventually, in 1975 and 78, posthumously, obviously, granted their citizenship rights back. Now, you might think that this is something that doesn't really count for anything anymore, that this is part of the 14th Amendment doesn't mean anything. Actually, folks, this is the part of the 14th Amendment where some of the states tried to disqualify now President Trump from being on the ballot because of his, what they alleged was his participation in the January 6th, what they call insurrection. And so they said, because of this, he can't be on our ballot. And Colorado actually said, we are not allowing him to be on the ballot. Well, of course, Trump sued and it went straight to the Supreme Court. And in all honesty, he obviously won because number one, that's nullification. States cannot nullify a federal law. they can't be the ones that declare Trump not being on their ballot. That's up to Congress to determine eligibility for federal office holders. And so, it was a good try on the part of Colorado and Maine, but it just didn't work, in their behalf. So that's it for the 14th Amendment. Oh, no, I was wrong. There is one other clause in the 14th Amendment we need to talk about, and that's the confirmation of the legitimacy of all public debts apportioned by Congress during the Civil War. That means that all the debts were valid that the Union had racked up, and they were going to have to pay all the pensions and bounties that they said they would pay for. Remember, as a Revolutionary War, there was a little bit of concern because the Articles of Confederation didn't provide for that, and a lot of Revolutionary War soldiers never were paid for their what they did in the Revolutionary War. And they said, we want to make sure that never happens with these soldiers. And so they put this in the 14th Amendment. It also confirmed that the United States nor any state would pay for the loss of slaves or debt incurred by the Confederate government. So they said, there's not going to be this reparations. We're not going to pay ex-Confederates for the loss of their slaves. And so they wiped that out. Now, again, this might be part of the 14th Amendment that seems just, historical and doesn't really apply anymore. Actually, there are people that say that this is a possible remedy for the repeated debt ceiling crisis that this country seems to be facing, where it seems like every few months we have to have this big kabuki theater thing where, we're going to raise the debt ceiling or are we not? And we're going to close down the government. And, it's me. It depends on whoever is in charge, that they're the ones that's going to be, really found at fault. A lot of legal scholars have suggested that placing a ceiling on the national debt is unconstitutional and it interferes with the duty to pay interest. And so this is probably something that's going to rear its ugly head here. In fact, I would be willing to go to Vegas and put some money on the fact that I'll bet at some point pretty soon, some president, maybe our current one, is going to exercise executive authority to raise the debt ceiling on his own, provoking a ruling for the Supreme Court as whether or not this applies to the debt ceiling crisis. So, stand by, see if that happens or not. I've got a funny feeling it just very well may happen because President Trump is fond of using executive orders. And it very well may be that next time or one of the next times that Congress goes into this whole kabuki theater thing about raising the debt ceiling, he might say, I'll just take care of it myself and I'll issue an executive order raising the debt ceiling on my own. And of course, that's going to prompt a huge crisis and a ruling from the Supreme Court. So it'd be interesting to see if that happens or not. Okay, let's move on. And we're going to go through these pretty rapidly, folks. The 15th Amendment, there were 3 amendments passed during the Reconstruction era. The 13th, freeing the slaves, the 14th, granting citizenship, as well as all these other areas that we've been talking about. And the 15th, which basically granted the right to vote to slaves. However, the Supreme Court in decades following the passage of the amendment interpreted it very narrowly. This allowed for a lot of southern states to enact what became known as Jim Crow laws that allowed barriers to voting by blacks. Most often, these took up the form of things like poll tax and literacy tax. They would charge everyone to vote. Well, yes, it was the same amount of money, but, let's face it, folks, most white people in the South probably could afford the tax better than most black people in the South at this period of time, who maybe had no money at all. Literacy tests. Remember, a lot of blacks were illiterate because they, were denied the right to go to school when they were slaves. And as a result, they couldn't pass a literacy test. And even when they could read and write, the South was very involved with this. They would issue the white people, they would ask them to read a sentence out of, some very simple book. and they may ask the blacks to read a sentence that was very complex in nature. And, they said, well, you can't read well enough to vote, so you didn't pass the literacy test. So it was being unfairly applied. So finally, they passed the 15th Amendment and they passed it. All these Jim Crow laws were passed. It would not be until 1965. Think about that. Uh, 60 years ago, when Congress passed the Landmark Voting Rights Act, which provided federal oversight of elections in discriminatory jurisdictions, banned literacy tests, it banned discriminatory devices, well, created legal remedies for people affected by voting discrimination. And eventually, they had to deal with the poll tax, which we're going to talk about here in just a few minutes, by passing what was called the 24th Amendment, because originally Supreme Court said that poll taxes were constitutional. So that was the 15th Amendment, granting the right to vote to former slaves. The 16th Amendment basically had to do with an income tax. Now, after the Civil War and Reconstruction, there was a period of time when there were no amendments passed up until the beginning of the 20th century in what became known as the Progressive Era, where you begin to see a whole lot of social changes going on, led by a group of people called progressives like Teddy Roosevelt and some of these people. William Randolph Hearst, the big publisher, was involved in this. And one of the things that they wanted to pass, and they passed about 5 amendments, one of them was called the progressive income tax. Now, believe it or not, we'd already had an income tax. There was an income tax passed by Congress during the Civil War in the North. But as soon as the Civil War was over, the Supreme Court ruled it unconstitutional, said you can't do that. So, in order to have an income tax, they had to go back and amend the Constitution. Prior to 1913, the basic source of federal revenue was tariffs. Sound familiar? Excise taxes, sales tax on goods produced. During the Civil War, there had been a temporary income tax, but it was lapsed after the Civil War and ruled unconstitutional. In the decades that followed, Congress attempted to pass income tax legislation, but they all failed or were ruled unconstitutional. But by the 1900s, there had become such a disparity of income. It seemed like the rich were getting very, very rich. People like the Vanderbilts and the Carnegies and the Rockefellers, these people were just, we think that, some of these people today, some of these tech people are very rich. Folks, compared to the Carnegies and the Vanderbilts and the Rockefellers, they couldn't hold a candle to these guys. These guys had so much money, they did not know what to do with it, literally. And so it was decided, because of the disparity, that they were going to have to amend the Constitution to pass an income tax. So what you had was, you had the very, 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 very wealthy at the very, very top. And then the vast majority of the people were middle income to lower income. And the higher income people weren't paying any taxes. And so it was decided we have to do something about this as the money became more funneled into the top of the spectrum. And so they passed the 16th Amendment, the first of the Progressive Era amendments. The second one was the 17th Amendment, which allowed for direct election of United States senators. If you don't know, the original Constitution provided that senators were elected by the state legislatures. That was part of the Great Compromise, where senators were elected by state legislatures, whereas the House of Representatives were elected by the people. And they thought this would be a way to kind of balance out the powers. It seemed to work in the beginning, because we had a group of people in the beginning that seemed to be really concerned with good governance. But as times went on, it seemed like, at least it seemed like, more and more senators were being bought and sold by the powers. And it seemed like it didn't have anything to do with competency. It had to do with what political party you belonged to and whether or not you could, you know, get the most votes by the state legislatures. And so by the end of the 19th century, you begin to have people like William Jennings Bryan and William Randolph Hearst began a campaign for direct election of senators, getting it away from the state legislatures and putting it in the hands of the people. Unfortunately, even though it passed, it didn't end the concerns of corruption. And I think we know this. I mean, it seems like every year there's at least one senator that comes up, with their hands dirty. We just saw one not too long ago, and it seems like originally it was kind of out of the hands. They wanted to take it out of the hands of the powerful people, the wealthy people. The problem is it costs so much now to run for either the House or the Senate, but particularly the Senate, that once again, it seems like the Senate elections are being bought by people that can afford to buy those seats through advertising or have the people that are willing to give them the money. Example, and I'm not saying any one of these people are bad. I don't want anyone to think that I'm suggesting these are bad people. But look at the cost. The race in 2022 between John Fetterman and Dr. Oz cost a staggering $373 million between the two. That's over $250 million for that one Senate race. That's how, folks, not very many people can afford that. I guess, if you're one of these very, very wealthy tech people, you can afford it. But, that's a lot of money. Even to rich people, that's a whole lot of money. And you're either going to have money or you're going to have people with big, deep pockets. And either one makes it seem like that office is being bought. So it's there is a movement, believe it or not. There is some people that think we ought to go back to the way it was originally, where senators are being elected by the state legislatures. I don't think that'll go anywhere. But there are people right now that are proposing that we go back to the original way the Constitution was written because this is working in their minds. That's everybody's opinion, okay? That everybody has a different opinion about that. Okay, the 18th Amendment. Boy, everybody knows what the 18th Amendment was. Again, it was one of those progressive amendments, and it had to do with prohibiting the sale, the transportation, and the manufacture of alcoholic beverages. It was ratified in 1919 and went into effect in 1920-ish, ushering in a 13-year period of prohibition. And it was brought about after a long-standing campaign by a couple of temperance movements called the Anti-Saloon League and the Women's Christian Temperance Union, both of them led by Carrie Nation, the lady up there with the hatchet. And we all heard the stories about how Carrie Nation would walk into a bar and start chopping the bar up with her hatchet, and who knows? I bet some of these may have been to one of those bars, I know I have. I've been to the Minger Bar on the outskirts of the Alamo. And the Minger Bar was one of those old saloons that have been around forever. And they've still got the original bar with the original chop marks of Carrie Nation, where, she came in and started chopping at the bar with her hatchet. Kind of an amusing story. I used to have a coffee cup for Minger Saloon because I liked that story so well. Believe it or not, I didn't go in there to drink. I went in there to see the bar. Okay. Unfortunately, the amendment led to a rise. I hear people laughing out there in my audience. Okay. Unfortunately, the amendment led to a rise in illegal importation and production of alcoholic beverages. There was an unintended consequence, which often happens with laws. And this was one of those amendments that had unintended consequences because along with making alcoholic beverages illegal, somebody filled the void: organized crime. people like Al Capone. It's said that Al Capone made $60 million annually. There's a prophetic story where Al Capone and the President of the United States attended a baseball game together. And when, as they do often, they announced celebrities in the audience, and they announced the president, who got booed, and they announced Al Capone, who was uproariously cheered. And they asked him later, they said, why did they cheer you instead of the president? He said, well, I had a better year, you know. Um, so, this was kind of the illegal, unintended consequences of prohibition, was a rise in crime, not just bootlegging, prostitution, gambling, led to the big crime era of the 1920s and early 30s, which is a story unto itself. And then we have the 19th Amendment, which finally gave the right to vote to women. Now, it's hard for me to believe, but I know there are women alive today that probably can remember. Well, yeah, maybe not. Uh, Maybe as children they can remember when the right to vote came about to women. It's just hard to believe that it's not been that long ago. That seemed like something that should have been accomplished a long time before. Women had been disenfranchised from the very beginning of the republic. Um, and even though some states had begun enfranchising women, giving them the right to vote, surprisingly, most of those states were in the West, by the way. It wasn't the East, the progressive states. It was the West because out there, women carried their weight, in farming and working the ranches. And the states in the West realized that women were a lot more important in that regard than, unfortunately, some of the progressive states of the East. Uh, but by the early 20th century, there was a push for the suffrage amendment. It began way back in 1848 at something called the Seneca Falls Convention in New York, led by another person that we've all heard of, Susan B. Anthony, along with a lady by the name of Elizabeth Cady Stanton. That's those two ladies up there on the top. And they began a suffragette movement, which took a long, long time. It took basically 70 years to get the amendment passed. And actually, the only reason it passed was because of World War One. Because in World War One, there were so many men that went to war, women began to fill the roles that were normally held by men, and people began to realize, hey, these people deserve the right to vote. I mean, they're doing things out here that we didn't know that they could do. Same thing happened in World War II on even a larger scale. And so basically, after World War One, the suffragette movement really took hold. And the amendment was passed by Congress in 1919, ratified in 1920 very rapidly, enfranchising 26 million women in time for the presidential election. Some people say the reason President Harding was elected was because of women. And I don't want anyone to take this the wrong way, but President Harding was a relatively good-looking man. Presidents, if you look back through portraits of the presidents, they all were not. In fact, most of them weren't what we would say were really handsome men. President Warren Harding was a handsome man, and a lot of people think that influenced the women's vote. I don't know that it did, and if it did, they were very sorry about it because he ended up being one of the more corrupt presidents in American history. But even at that, Black women were, even though they were included in the amendment, they continued to be denied the right to vote because of the use of what we call Jim Crow laws. So that's the 19th Amendment. The 20th Amendment was passed to rectify what was called the lame duck era. Now, originally in the Constitution, the national elections were held the first Tuesday in November. That's specified in the Constitution. And then the president and the Congress took office at the beginning of March. There was a 5-month gap. that kind of made sense in the 18th century, the 1700s, because, it took a long time to get things. Transportation, communication were primitive to say the least. People that were elected to office often had to settle their affairs and move. And, it took a long time to get all this done. So it kind of made sense in the beginning. But as things progressed, it didn't make so much sense. And so by 1932, there was a movement passed, and this was the last of the Progressive Era amendments. There was a movement that began after FDR was elected president because it took him 5 months to become president. And remember what was happening in 1932. We were falling into the Great Depression at a rapid rate. And he was telling everyone, hey, I was elected to take care of the Great Depression, and I'm sitting around here twiddling my thumbs because of this Constitution. And there were people who said, hey, this no longer is necessary. We don't need a 5 month gap between electing our officials to run the government and them taking office. So they passed an amendment in 1933. It was proposed and ratified in 1933, basically reducing the time. Now, Congress takes their office, I think it's January the 6th. I may be wrong on that. And the president takes their office on January 20th, normally. And so, they basically reduced it to a 2 month instead of a 5 month gap there, which made a lot more sense. As it turned out, FDR almost didn't take office. I don't know if you know this or not, but FDR was the target of a serious assassination attempt by a radical by the name of Giuseppe Zangara in February of 1933. And he tried to assassinate FDR, almost got it done, but instead he missed and killed the mayor of Chicago in the same car. And so he narrowly escaped assassination before he even took office, which I don't know what would have happened. That would have been a disaster for sure. Okay. Well, by 1933, there was another amendment passed, and that was the amendment to repeal the 18th Amendment. After 13 years of prohibition, people said enough is enough. It really didn't have the effect everybody thought it was going to have. There continued to be alcohol. People were bootlegging. Everybody, there were bootleggers everywhere. It didn't matter where you were, the big cities, the Ozarks, the West, it didn't matter. There were bootleggers making, bootleg alcohol. And as a result, they said, we thought this was going to work. It didn't work. We need to repeal it because not only that, it's ushered in this huge crime wave in the United States. And so they proposed and ratified the 21st Amendment, which repealed the 18th Amendment. That is the only amendment ever to be repealed after it was passed. The 21st Amendment is also the only amendment to be ratified by state conventions. Remember, the Constitution says there's two ways to ratify a constitutional amendment. It can either be ratified by state legislatures, which is how every amendment to the Constitution is ratified, except for this one. And the other way was saying every state can hold a convention of elected people. People in their home state can elect people to attend a convention, and the people can approve or disapprove the ratification. And the reason they chose to let the people do it was because a lot of politicians didn't want to face the temperance movement. It was still pretty powerful. And they said, hey, we're not touching this with the 10-foot pole. If you guys want to repeal it, you can repeal it, but we're not doing it. And so the state legislatures kind of backed off and said, forget that. We'll let you take care of it. And they did. So the 21st Amendment was passed, allowing the manufacture, sale, and distribution of alcohol. Happy days are here again. Beer is back. You can see the poster over there. It didn't prevent state and local governments from restricting the process, and many states uh, passed laws making themselves dry or counties or cities becoming dry. In fact, the case you may not know this, Mississippi was totally dry until 1966. It was illegal to, buy or manufacture alcoholic beverages in the state of Mississippi until 1966. Kansas prohibited public bars and then until 1987. I didn't know that until I started doing this research. I was kind of shocked at that. Believe it or not, folks, there's a lot of dry areas still. Look at this map. Now, it probably shouldn't surprise you about some of them. The counties in red are what's called dry counties. And you notice Kansas, Western Kansas has several, as does Oklahoma. Arkansas probably has the most. I'm familiar with that. I know that there are a lot of dry counties in Arkansas. Tennessee has some, Mississippi has some, Texas a few. Surprisingly, Kentucky has quite a few dry counties, which kind of shocks me because when you think about Kentucky, you think about, whiskey. And you kind of think, that's kind of amazing that there would be so many dry counties in the state of Kentucky. What also amazed me was how many states are what they call mixed states up in the upper West, like my home state now of Michigan that I live in, is almost totally mixed, allowing every county to make a decision for themselves. Now, that doesn't mean they're all dry. Trust me. I live in Grand Rapids, Michigan now, and the nickname for Grand Rapids, Michigan is Beer City. I didn't know that till I moved here. But there's a lot of alcohol in Michigan, but yet most of the state can make the decision about being dry or not, as can Ohio and Pennsylvania, South Carolina, a lot of Texas. So these are the dry counties and the mixed counties, allowing states to make that decision. You notice my old home state of Missouri is totally 100% wet, as is most of the West, and most of the New England area. Okay, now, 22nd Amendment. 22nd Amendment was passed basically to make sure that presidents did not run for more than 2 terms. Now, it had been an unwritten kind of tradition ever since Washington and Jefferson not to run for a 3rd term. Washington made this very clear. He said, I don't think that presidents need to run for more than 2 times. And Jefferson said the same thing. They both could have been reelected. There would have not have been any problem, particularly with Washington being reelected. And Jefferson would have been reelected easily as well. But they said, that's it. 2 terms is enough. And from that point on, every president, basically, even though it was not specified, they could only run for 2. That was the maximum number that they ran for. In fact, if you look back during that period of time, very few presidents actually ran twice and won. There were a few: Andrew Jackson, Abraham Lincoln, but for the most part, presidents only served 1 term until the 20th century. And then we got into this situation with FDR. FDR came in on the beginning of the Great Depression, and he was reelected easily in 1936 because the Great Depression was still going and people kind of felt like he was doing a good job. And then when it came time for the 1940 election, what was going on? Well, the Great Depression was just ending, and World War II had kind of already started in Europe. And people said, boy, I don't know if we need to be changing presidents right now or not. And so they decided that they were going to reelect FDR, and he made the decision to run again for his 3rd term, defeating Wendell Willkie. And then 1944 rolled around, and even though he was in ill health, a lot of people felt like he didn't need to be running because he wasn't well. He ran against Thomas Dewey, very popular governor of New York, and defeated Thomas Dewey for the 4th term. only served 82 days. He died within about 3 months, less than 3 months of being serving in office for his fourth term, meaning Harry Truman basically served out his fourth term. And then, of course, we all know that Harry Truman won re-election in 1950, and you know, pardon me, 48, and was defeated Thomas Dewey again, even though nobody expected him to do it, as you can see by the headline there, the famous headline, Dewey defeats Truman. And so all of a sudden, the people in the House and the Senate said, and Truman was not a popular president amongst the people that ran the government. He was kind of popular amongst the people because he was they kind of liked him, and as a result, there were people that were scared that he was going to try to make a third run for president, and so they passed the 22nd Amendment and rapidly was ratified, making sure that no president could ever run for 2 terms, 3 terms again. Now, we all know what's going on right now. We've all heard the stories about President Trump, who's everybody's having these conspiracy theories that he's going to make a run for president again, a third term by, making sure Vance runs for president. He's going to run for vice president, and then when they take office, Vance is going to resign. He's going to become president. There's 2 problems with that. Number one, there's no guarantee that Vance will run or that he will be reelected or elected. And number two, I'm not for sure that Vance would resign his office. He's a pretty shrewd politician in his own right. So I'm not for sure that that's going to make any sense. But there are, believe it or not, there is a movement afoot right now to amend the Constitution to make it say that anybody that is not qualified for the president cannot be qualified for vice president. In other words, you cannot run for vice president if you've been the president for 2 terms. Be interesting to see if that goes anywhere. Don't think it will, but there's people that are talking about it. The 23rd Amendment has to do with the District of Columbia. The District of Columbia was set aside in the original Constitution as the seat of national government, and the framers of the Constitution wanted it to be a neutral area. And so they gave the power to run the District of Columbia to Congress. The original Constitution says to exercise exclusive legislation in all cases over such district as may, by session of particular states and acceptance of Congress, become the seat of the government of the United States. So that's how that was set up. Unaddressed by the amendment was a couple of issues. Number one, congressional representation. Do the people of the District of Columbia get the congressional representation? And number two, do they get home rule? Well, Congress eventually granted home rule to D.C. So they have a mayor and they get to basically make laws for themselves now. And they also allowed for a non-voting delegate to get elected to the House of Representatives. In this case, it's a lady by the name of Eleanor Norton Holmes. She's been the non-voting representative for many, many years from the District of Columbia. There is an amendment that has been proposed and was up for vote starting in 1978 that would have granted statehood to the District of Columbia. The problem with it is there was a sunset clause. And the sunset clause basically said if it doesn't get the necessary 3/4 votes by 1985, it's not going to happen. And it did not get the necessary votes of all the states. So it died. So again, there are people that want to resurrect this thing and say the District of Columbia deserves the right for full statehood, which would, in a sense, grant 2 senators and a House member to the Democratic Party, because the District of Columbia is probably the most Democratic party area in the United States of America. Again, I'm not taking sides. I'm just saying that's the way it is. Everybody knows it. By the way, they are not the only government area that has a non-voting member in the House of Representatives. Puerto Rico has one, Guam, the Virgin Islands, American Samoa, and the Northern Mariana Islands. These are all territories of the United States, and they all have non-voting delegates to the House of Representatives. They get to participate in every way except their vote doesn't count. You know, they get to debate, they get to do everything that the representative gets to do, except they don't have a vote. That counts. They can tell people how they would vote, and they can try to sway people to vote this way. Puerto Rico, there's been a lot of movement to make Puerto Rico the 51st state. I don't know that it'll ever happen. It might, but I kind of doubt that it's ever going to happen because, again, people are they like, we Americans like everything structured, and 50 is just a nice number, and I know that sounds silly, but I think that there's probably not reason to believe that. Okay, I got to move on. 24th Amendment. 24th Amendment, whoops, sorry about that. 24th Amendment basically eliminated the poll tax. The poll tax, as I said, was one of these Jim Crow era things where they basically said you have to pay to vote. And the Supreme Court originally said poll taxes were constitutional, so they had to pass a 24th Amendment, which was passed in 1964, eliminating the poll tax, making it unconstitutional. You cannot have that. The 25th Amendment, and we really want to talk about this for a few minutes here, okay? 25th Amendment came about as a result of the assassination of John F. Kennedy. John F. Kennedy was not the only president to be assassinated, obviously. We know that. But no president had been assassinated since William McKinley. And as a result, medical science had progressed rapidly in the 20th century. And it became very apparent to some people that had JFK survived for a long period of time, and he could have, medical advances had progressed to the point that you could have a president that was incapacitated for a long period of time. And that would mean who was running the government, okay? So they passed the 25th Amendment in 1965. It did several things. First of all, it did the obvious. If a president was declared unable to discharge his powers, he was basically, the vice president could take over. If he died, if he resigned, it was removed, the vice president could come in power. It also provides for a process for selecting a new vice president. So we've seen that happen. Gerald Ford, when he became president after Nixon resigned, he chose Nelson Rockefeller as his vice president. And so, he was not an elected vice president. Ford was not an elected president, which makes it kind of an unusual thing, okay? Didn't last but 2 years. It also provides for the president to voluntarily give up his powers for a period of time. It also allows for the vice president and a majority of the cabinet to basically take away the power of the president. So let's talk whatever. I think we know there is a lot of people that feel that Joe Biden was not at his best at the end of his term. There are people that feel like he should have been basically ruled incapacitated way before he was, left office. I'm not getting into that argument. That's everybody's decision to make. And this is not just a conservative or a Republican argument. There are people on the left that feel that as well. And a lot of people say what should have happened was Joe Biden, the vice president, Kamala Harris, and the majority of the cabinet should have ruled that Joe Biden was no longer capable of discharging the office as the president. Now, obviously, Biden would have fought that, okay? And his family would have fought that. So what happens then? Well, he can issue a notice to Congress that said, no, I am capable of running the office of president. So what happens then? You got the vice president and half the cabinet saying he's not. You got the president saying he can. It goes to Congress, and Congress has to have a decision by 2/3 vote of both houses to determine whether or not the president of the United States is capable of serving office. Folks, that would be, in my opinion, an absolute disaster if that ever happened. I don't know. I can see this being drawn out for months and months and months. Experts on both sides being called in. And I can see this paralyzing this country. I hope that amendment is never used because I can see how it would create all sorts of really bad, serious problems for this country if the vice president and the cabinet ever decide to take over the powers of the president from the president. I'm not saying that it doesn't need to happen on occasion. I'm just hope that it never happens because I can see it happening and I can see it being a real disaster if it does happen. The 26th Amendment, really simple, granted the right to vote to 18-year-olds. Probably the fastest proposed and ratified amendment in the history. I'm not for sure, but I think it probably was 4 months. It took 4 months to propose it, 4 months to ratify it. Reason, pretty obvious. We had kids going to Vietnam fighting the war. Look at this young soldier up here. He looks like he's 15 years old and he's fighting in Vietnam, and yet he can't vote till he's 21. And people said that is no way to do it. Old men bring about wars, young men die in them. And people were saying, if you're old enough to die in Vietnam, you're old enough to vote. And so they passed the right to vote to 18-year-olds. You may agree with that. You may disagree with it. I personally think it's probably not had that much of an effect upon elections, particularly until recent years. And it seemed like more and more young people are voting now. But there were years there when young people didn't vote. Last amendment, and then we're going to be done with this. Mr. Watson's amendment. In 1789, James Madison gave his list of 12 proposed amendments to the Congress for ratification. They passed 10 of them, made it the Bill of Rights. One of them that did not pass was an amendment that stated that any law that increases or decreases the salary of Congress may take effect only after the next election. So Congress can't pass a raise, can't raise their salary in the year in which they're serving. They can pass a raise, but it won't take effect until the next election. It died. It died because it didn't get the required number of votes in the states. But it sat there, and frankly, most people forgot about it. In 1982, 19-year-old student in University of Texas was doing a research paper, and he wrote about this amendment and said, there's no sunset clause. The amendment was pretty close to passing. It's still out there. And so he went on a crusade, became pretty famous for it, and actually got the thing passed. Took him 10 years. But in 1992, the amendment finally was ratified 202 years later, making it holding the record for the longest period of time between proposal and ratification. What's going to be the next amendment passed? I have no idea, folks. There's all sorts of people out there proposing 28th amendments, but who knows what's going to happen. Well, that's it. We're done. I run a little long today. Next week, we're going to start a brand new set of presentations. I'm very excited about this. I'm going to go back to my roots and do narrative history. We're going to talk about the Civil War and the Reconstruction era. This will take us quite a while, but I'm really excited about it. I've been working on it now for about 5 months, and I think it's going to be just a terrific presentation. I hope you tune in. I hope many of the other Aero communities tune in. I think you'll enjoy it. Civil War is one of those areas that a lot of people really enjoy. So with that being said, I'm going to let you go. And we will see you hopefully next week when we start a brand new set of presentations on the Civil War. You people out there in the communities that are watching this, tell your friends about it. Tell them to show up and see if you like it. So I will let you go, and we will see you hopefully next week.